My name is Andrew Godwin, and I'm an Associate Director of the Melbourne Centre for Commercial Law, which is one of the organisations or research centres that is hosting today's seminar. The other one is the Centre for Artificial Intelligence and Digital Ethics. And so I'd like to welcome all of you, also on behalf of the directors of the two centres, both of whom I think are here either in person or via Zoom, Rosemary Langford, who's the Director of the Melbourne Centre for Commercial Law, and Jeannie Patterson, who may be with us online, who is Director of the Centre for Artificial Intelligence and Digital Ethics. I'd also like to thank the Obligations Group for helping to promote today's event. Let me begin formally by acknowledging the traditional owners of the land on which we meet. In our case here at Melbourne Law School, it's the Wurundjeri, Woi Wurrung and Bunurong peoples. I'd like to pay my respects to their elders, past and present, and also extend a warm welcome to any Aboriginal or Torres Strait Islander peoples who might be joining us today. So thanks again for coming along this evening. It's always good to see a good turnout. I think that's testament in part to the quality of the speaker and his reputation, but also, of course, the inherent interest in the topic, namely artificial intelligence and trusteeship. Before I introduce our guest speaker, Professor Donal, I thought it would be interesting just to reflect on how pervasive AI and issues relating to AI are today. Everyone, I think almost everyone, at least in academia, is increasingly working on issues that touch on AI and the implications of AI. By way of example, one area in which I've previously been involved, or one might say dabbled, that might be a more accurate way of describing it, is directors' duties and whether it might be said that directors owe a duty to use AI, whether a duty to use AI might be part of or be considered to be part of the existing duties to which directors are subject. And if so, if they are subject to a duty to use AI, what does that mean? Are they remiss if they don't use AI? What about if AI would help them to fulfill their functions as directors or help to mitigate risks? And how does this play out in relation to areas in which human discretion is required or has to be exercised? Similar issues, I expect, Scott, arise in relation to trustees as they operate in various contexts, including in the area of superannuation funds and superannuation trustees, which leads me to the topic for today's seminar and our guest lecturer. Scott Donal is a professor in the School of Private and Commercial Law at the University of New South Wales. Scott joined the faculty in 2010 after a successful career in the funds management industry, advising governments, superannuation funds, insurance companies, and fund managers on a range of areas. Scott publishes in both the academic and professional press on research relating to financial services regulation, governance, and superannuation policy. Scott's a good friend of Melbourne Law School, having worked closely with us on various projects, including, I recall, a special edition of the Company and Securities Law Journal in late 2020 as the Australian Law Reform Commission was gearing up for its inquiry into the simplification of the legislative framework for corporations and financial services regulation. More recently, Scott has published a paper in the same journal titled Artificial Intelligence and Super Fund Trusteeship, a paper that examines many of the issues to which Scott will be speaking tonight. It's a very comprehensive and thoughtful paper, and I'd recommend it to anyone who'd like to explore the issues in more detail. But without any further ado, let me welcome Scott and invite him to speak.
Thank you to Rosemary, Andrew, Ying, Jeannie for the opportunity to present this evening. I'd like first to acknowledge the traditional custodians of the land which we meet tonight and pay my respects to elders past and present. Their wisdom and connection to country continue to inspire and inform us as we wrestle with the myriad of challenges we face today. We're going to look at something that's quintessentially modern, artificial intelligence, and consider it against the frame of something that's been developed over centuries, that has wisdom baked into it, curial consideration, statutory means, and so on, i.e. trusteeship. So let me be clear at the outset. This isn't a how-to guide for AI, nor is it intended as a critique of AI, although there are some aspects of the use of AI that will be, I guess, a little critical. AI, I believe, has its uses, both generally and for trustees. What I hope to do is look below the hood, as it were, with lots of metaphors, of both AI and the law of trusts. At that level of granularity, we see more conditionality and nuance about how trustees could and ought to or ought not to use AI than is typically presented. Andrew mentioned the paper that's out there in the Company Securities Law Journal. There's a lot of detail. There's 30-odd pages in there. I'm not going to be able to go to that level of detail. Some of that is generalizable. So it's not just about super fund trustees. There's lots of things trustees do in common. Particularly trustees of managed investment schemes would do certain things that would be similar to a super fund trustee. Trustees of charities would also have similar sorts of issues in some areas. Why, as a trustee, would you be considering using AI? Let's just quickly remind ourselves, it's fast. Trustees are almost always resource poor. So AI can be expected to consider all the relevant factors and do so in an analytically rigorous manner, and almost always derive decisions in a way that, although not linearly determined, incorporate a myriad of different possibilities, probabilities, conditionalities in a rigorous way. That's attractive to a trustee. It's also claimed to be cheap, and I want to contest that. I want you to think a little bit about that. I speak to lots of trustees of superannuation funds, and they're being pushed by the commercial managers to put it in because it's cheap. Well, basically what's going on here is a classic exchange that microeconomists understand of variable costs, fixed costs. The variable cost is every time that the claims committee has to meet or some other committee has to meet and make a decision, you've got to bring all the people together, take it. And it's very difficult to get leverage on that. Compare that to the fixed cost of building a machine model, an AI model that can drag in lots of information, work through it all, and come to a decision or at least come to a recommendation. What you're doing is you're exchanging the variable costs of having 6 or 8 or 4 human beings sitting around a table meeting every month or more frequently to make a decision with the considerably larger but once-off cost of building an AI model that can do much of that for you. Assuming that is that the AI model can be static, that you can leave it and you can let it run for a period. If every 3 months the government changes something and you have to change some of the parameters in the model or something else happens you need to model, then the cost-benefit analysis is different. But it is a very simple trade-off there. People aren't seeing it that way. They're just seeing it as being cheaper because you can keep running it and everything to work. So I encourage you to think more carefully about that. The other point that's on there is FOMO, fear of missing out. Now, in most contexts, we think of fear of missing out as being a bad thing. You know, it's not really a criteria that most people would think would be acceptable. Except when you think about the way in which the standards we expect of trustees, and directors also, to your point, are measured, the standard to which they're compared. Now, I don't know whether the Clapham Omnibus actually travels past the Chancery Courts. Probably doesn't. I know a little bit about the geography of London. I can't see how it would. But there's clearly an element that in understanding what would be expected or what would be of a trustee, you would be looking to think about what the community standards were, what sorts of practices were in place. And so you raised the issue of would a director be criticised or perhaps even held to be in breach of a duty of care if they didn't use AI? Well, there's nothing in the Corporations Act that says you must use AI. But if the standard practice is that certain things have been used, the population as a whole, the peer group is using AI for certain things in certain ways, then that starts to perhaps inform the court as to what's an acceptable or expected standard in that regard. And I think the same thing happens here. So a kind of pejorative sense of FOMO, I think we need to look at that a bit more carefully as well. So there are some reasons why trustees ought to be looking at AI. Some of them are, I think, not as strong, and some of them are stronger than are currently appreciated. So we all have great fun reading the press and hearing about the latest thing that's happened in, the AI, the lawyer who's been embarrassed in court because they've referred to cases that turns out don't exist. The diagram on the right is actually quite a famous one. I didn't actually generate it. That's at one stage, that's what happened when you typed into one of the AI models, man surrounded by sharks. It strictly speaking is true. That is a man surrounded by sharks. But if that was happening to me, I'd be very worried. That's kind of Sharknado territory, I think. Some of the older members of the audience will remember HAL taking over Singularity, where the machine suddenly starts to have a mind of its own and an autonomy of its own. Some of my favorite ones there, the one actually third from the left, as you're looking at it, which was Air Canada. People heard of this story? What happened with Air Canada? They had a bot, which was a customer service bot. And some industrious young AI experts or would-be experts kept peppering it with questions and ideas until ultimately the bot offered them free tickets. Air Canada did not want to accept, did not want to provide, and the court said, no, you've provided this bot to the marketplace, it's on your website. That's a representation, or it's an offer that's being made. You have to respect it, you are bound. So there's lots of interesting stories, but I find sometimes that the color of the stories gets in the way of the substance of what's actually going on. And so there's very superficial understanding of what's actually the issues. And I want to spend a few minutes now, if I can, just talking about that, because that you need to understand that level of granularity to then plug it against what trustees do to see where the issues might be. So the first one is, you will often hear people talking about AI hallucinating. It hallucinates, it comes up with things that aren't true. I'm here to tell you that that is not correct. That's not the right way to think about it, and it matters for those of us in the audience who are lawyers, because for a very particular reason. Hallucination is when I regard something that I see as true when it isn't. Right? The mirage in the desert. It's not there. I see it. I think it's true. But AI models don't do that because they don't care whether it's true or not. That's not what they're trying to find. They're trying to find patterns that help to explain the outcomes. So they want to use those patterns to apply to specific tasks. AI models also don't lie. Lying is where you say something knowing that it's not true. AI models don't do that. The lawyers in the room and online will be going, oh, hang on a second. When I think about the various offences and criminal laws and corporations law, duties and so on, that what's going on in the mind of the person who's alleged to have breached actually matters in many cases. And so we need to have a better understanding of how to understand what's going on. Moral philosophers have a word for it. Professor Frankfurt of Harvard University calls it, and I'm going to use this word once because I don't like using it, I don't like writing it, bullshit. I'm going to just refer to that as big S now because I find it uncomfortable using that word, but that's what's going on. And that's making a statement without caring whether it's true or not. We might think about various public figures who might be accused of doing exactly that. So they're not lying. They're not hallucinating. They're making a statement, and the register of whether that's a statement to make or not is not the truth. It's not the semantic truth. It's something else. And that's a real problem when you get to trusteeship. It's a real problem when you get to other types of fiduciaries and other sorts of decision makers from a legal perspective. Because as someone who is employing an agent or employing a technology where you know that the truth doesn't matter, you are very exposed if that decision comes to be reviewed in court. Okay. Opacity is also a problem. We like to know why it was that the decision was made, or what was the process by which a decision was made. We know about the difficulties of corporate attribution, working out where the decision was made within a big corporation. But the problem in many AI models is that the way in which the model arrives at its solution is actually impossible to track. Now, there are technologies that AI people are very smart, there's lots of them, they put a lot of effort into this, that will track, claim that they will track how a particular decision came to be made. The problem, though, is that you can trace between starting point and end point, but what you don't trace is all the choices not made, all the tracks not taken, of which there will be a myriad. So you will cripple your AI if you try to track every single thing. I mean, that's what the AI has done, right? It's gone through all those things. So it's actually very difficult. I'm not going to say it's impossible, but it's very difficult, and using current technology is very difficult to backtrace. And that can be legal. That can be a really big problem in a legal context. I'm not going to talk too much about historical bias, except to note that the data you use to train the model is really important. So there's some stuff in the paper that goes into that in more detail, particularly in circumstances where you're dealing with, if you're a superannuation fund trustee, which is the example the paper has, you're dealing with private data, you've only got a limited number of members and so on. These models are trained typically on enormous data sets, far bigger than biggest funds we have, far bigger than we can typically generate. So then you have to think of other ways to train it. And finally, scheming. I love this one. This is the one that is HAL, right? This is the one where we've got to think about what objective are we going to set for this model? What's it going to be trying to achieve? And what are we going to let it do? So for instance, one of the Google models that they had where they had practicing negotiating between two models. They started off speaking English, and by the end of it, they were whirring in beeps and bops, which humans couldn't understand because the machines had worked out they could do that more quickly than use English. No one had thought to specify that in creating this artificial bargaining model, that you had to do so in ways that were intelligible to humans. Right? It's very difficult to anticipate all of those. When I'm talking at superannuation conferences, and we're talking about how do we derive a strategy that's optimal for members as a whole. I'm sure everybody here is probably a member of a super fund. Different ages, different backgrounds, different balances. We need to respect all of that and find an outcome. What you have is a small number of very, very old or older members who have lots of money, lots of others who have less money. If you're setting up insurance for them, you might have some people that have are in high-risk jobs, some of them that aren't. There's diversity. What's to stop an AI working out that the easiest way for, I won't mention a fund because there's some super people in the room, but sometimes I do it, but I won't do it today. What's the easiest way for some of those funds to get insurance, TPD insurance, disability insurance, for a diverse group of members? You pay the risky ones to leave the fund. Or you make sure that you don't attract them in the first place by putting things on your website that say, because that drives up the cost. It's a lot easier to deal with people who are working in offices and have particular health attributes. You just discourage them. Now, no human trustee would feel that was an appropriate outcome, but a machine might. They might think it's actually worth paying the money to advertise or to encourage those people to leave. I'm not suggesting for a second that that is actually a rational thing to do, but we need to think carefully about how do we keep the decision-making on-piste. We don't let it go off into all sorts of alternatives. Because the thing is, once it starts to do that, it can be difficult to work out what it's done. So I encourage you, as you're thinking about AI, you need to be thinking about exactly what the model is, how it's working, and what sorts of risks that might throw up. I've just thrown a few out here just to kind of wave the flag a little bit, but it's the level of analysis in the marketplace at the moment in terms of where the risk might lie is very deficient. So my next little rant for the afternoon is that trusteeship is qualitatively different than some other, not all other, but some other types of decision making. In particular, as a trustee, classically, you are required to act in the interest of another or of others, if you will. That's different. I can take, I was going to say I could take with money in my pocket, but actually we don't carry money around in pockets except in plastic form these days. But in the old days, I'd have been waving $20 notes and I could take this down to Flemington, throw them on the GGs or something. No one, they might not feel that was appropriate, but they couldn't really do anything about it. You can't do that as a trustee. You're acting for somebody else. You're going to be accountable to those people. What the courts have done is develop a range of principles around that the trust lawyers in the audience will be very familiar with, around requiring the trustees to give real and genuine consideration to all the exercises of power. Now, it does sound a little bit like the duty of care, and that's true as well, but there's something a little distinctive going on here, I think. It seems to be genuineness is a distinctive quality. Sure, it depends on the context. Justice Mahoney and Hardigan talks about you have to have regard to the exercise of the power and generally to what it involves. But it seems to me it goes to an engagement between the decision maker and the question at hand. There's a much closer association that it's trying to convey and require of a trustee that is not necessarily the case of other decision makers. This ties in with the doctrine around veteran discretions. Those of you that are trust law aficionados, and there's a few people in the room I know who are, the whole idea that the exercise of discretion has to be exercised by the right person at the right time with the appropriate information. All of this is going to try to create a decision environment that is particular and peculiar to this office of trusteeship. It also ties in with delegation. This idea that you actually have to exercise the discretion yourself. And McPhail Dalton, Lord Wilberforce talks about that the person who was appointed as trustee, there was a reason for that. They were appointed because they were that person. They had some knowledge, they had some attributes that meant that was appropriate. So what does that have to do with modern investment trusts? Surely they're not like the old family trusts, the dynastic trusts, except that we require both managed investment schemes and superannuation fund trustees to be licensed. There's a whole bunch of things that go into that, fit and proper, a whole bunch of other sorts of requirements. So actually, we do care about who we allow to operate these big investment trusts. Charities as well. We don't weigh heavily on charities because we don't want to suppress charitable giving, but increasingly the ACNC is starting to collect information and try to conduct investigations and so on. Again, to ensure that it's the right people, or at least perhaps maybe not it's the right people, but it's not the wrong people, or they're not doing the wrong things. So there's something peculiar, it seems to me, about trusteeship. And if you look through the policy discussions in the 1990s about what sorts of vehicles should be used for super, and similarly in discussions around what should be used for MIS, you see it time and time again, this kind of invocation of they're fiduciaries, there's something special about that, and we want that protectiveness. For those who are really trust law aficionados, there's another little thing that's going on here, which is when we're playing with the doctrine of powers, as opposed to the duty of care, we get a whole different set of remedies available to us. Remedies like falsification. And we could have Michael up here, and Michael could tell us all about all the details around some of that, but it's different in terms of the causal links that you need to establish as a lawyer. It's different in terms of the orders that can get made. It's also different in terms of the onus of proof beyond a certain point. I won't spend too much time on that because I know there's all sorts of different interests across the group, but that's a really important issue. But it's not just the arcanery of chancery practice and equity, because if you're in one of those trusts that AFCA has jurisdiction to review decisions made with respect to particular individuals, the first thing they do, if you've ever been there, Mark would attest to this, the first thing they do, if someone makes a complaint to AFCA, AFCA says, okay, trustee, tell us how you made the decision. Give us your reasons, right? It's not, they don't need you to kind of bare your soul, but you're expected to be able to demonstrate the process. And that could be a problem. I don't know how many fans of Little Britain there are in this room, but computer said no is not a good defense. The courts or AFCA is not going to go, oh, that's all right then. Right? You need to be able to demonstrate how these things happen, but you've got an opaque model. It doesn't tell, you've got no idea why it got to that route. It might be the right answer, but you can't show it. So that's a problem, practical problem. You also in super have a particular problem that I could rant about this a lot, but the Parliament changed the onus of proof in relation to demonstrating that you've acted in the best interests of your members. They flipped it. And so once the allegation has been made, as long as there's some kind of prima facie case for it, it's then up to the presumption that it isn't in the best interests of members, and it's up to the trustee to demonstrate the decision they made was. So if you've used AI to generate your decisions or to support your decisions, you're going to have to find some way to explain what it was that AI did, what it contributed to the decision. But that's all right, because we're going to keep a human in the loop. I won't ask how many people have heard that expression. Human in the loop is this idea that somehow we're going to run the machine and then someone's going to sit there, someone wise like Andrew, is going to sit there and look at the output and determine whether that's to be allowed to go forward. So here's my problem, much as we love Andrew. I mean, you do that, he did that job really well in between the other things you're doing. If Andrew never intervenes, that's a bit of a problem. If he intervenes too often, someone's going to look at it and go, so who's actually making this decision? Half the time he's making it. And there's no process behind him. He's just waking up one morning, he gets his morning croissant and his coffee, and he sits down and goes, yeah, no, swipe right, swipe left, whatever. So much thought needs to go into what is it that the human in the loop is actually doing. I put it to you that if the human in the loop is only doing what the machine is doing, then that's pointless. I put it also to you that if you can define what the human is doing carefully, you can put that into the machine as well and have the machine have regard for that. And the question might be, why didn't you? And you can sleep in a bit longer or enjoy his croissant more. This whole issue of the human in the loop argument, it's convenient, it sounds like it's going to be effective. Actually, I think could be a real problem. Trying to work out what is the role played, what does review mean, what are the criteria for that review, how do you monitor what the review is? In my darker moments, I think about becoming a plaintiff lawyer in the superannuation industry and just running at people, because I suspect a lot of these things haven't been worked out yet. But organizations will need to be thinking about this kind of stuff, because it does leave them very exposed. I want to finish up very quickly. I did say I wasn't going to speak for half an hour, but that was a lie. How might AI, it might also be BS, so I'm not sure. How might AI be employed? Okay. If you're out in the marketplace speaking to trustees, speaking to financial services companies, speaking to others, we can make these slides available to you. Sorry, you don't need to add techniques. There's lots of different ways that they get used in investment strategy. The paper talks about some of them, but there's a myriad of different ways that they can get used. I'm not really proposing to do it. What I'd like to do is just jump to the next slide, which is sort of starting to get to the conclusions. Where do I think it might be risky? Based on my description of where the risks are, and my description of the sorts of considerations that the courts and AFCA and others might have in terms of looking at decision processes. Any time that accuracy matters, AI is a bit risky. Like Andrew, I had to fill in some application forms in the middle of last year that were really important to the progress of my career. I went in, couldn't find them on the university website. Open AI, whatever it was, gave me the suggestion. Had I done that, I'd be here as an associate professor, because date that it found was the average over the last few years, and it was a month. It was like a week out. The application date was a week before what proudly there in my Google search. So anytime when accuracy is really important, reporting things to members, because if it's wrong, they can almost always take it somewhere and get compensation. Regulatory reporting. I don't know that there's actually an action. Rosemary might know this. Reporting inaccurately to the ACNC. I'm not sure if what would happen if you did that. But certainly if you report inaccurately to ASIC or any of the other regulators, you could be in lots of trouble. I would be careful if you're running a super fund at the very highest level, because there's actually a covenant that is specific to the trustees that they must formulate and give effect to a investment strategy. And I think that's starting to really point back to this idea that we want that group to do it. We don't want to delegate it out to other people. Now, lower down in the investment strategy, some of the other decisions, AI might be useful, but at that very top level, you need to be careful. Regulatory summaries. One of the first, and one of the reasons I got interested in this, I was at I don't do this very often, but I was at a tax conference, and I was chairing it for some reason, this particular session, and a senior member of the management team at the Australian Tax Office, right at the end, an accountant put their hands up. I do lots of small business accounting. The Corporations Act looks really, really complicated. What can I do with it? I reckon I'm going to be audited for sure. The tax commissioner, assistant tax commissioner, said, "Don't worry, you could just put the Corporations Act into AI or ChatGPT into ChatGPT, and it'll summarize it all for you." I'd already left the stage, more or less. I got back on and said, "I'm really sorry, but that is the worst advice I've ever heard. Do not do that, because you don't know whether it's going to get it right." There's all sorts of stuff sitting in the Corps Act, and they could play into play in all sorts of different complicated ways. That's not how we do corporations law. Anyway, so board meeting notes. I don't know how many people here have actually been involved in litigation where board minutes have been brought before the court. You don't want those to be something that you can't explain where they came from. Where you could use it, I think you can certainly use it to collect data and stuff on where there's decisions that need to be made, because there will be inevitably others involved in using that information. You need to be careful. Originally I had qualitative stakeholder communication, so emails going out to people, reports and so on, answers to annual members meetings. Until we started to have greenwashing cases that said, well, actually, you've said this, and if you interpret it this way, or if you're not very generous with your interpretation, you can write us a check for $12 million. So again, this is a situation where it's increasingly obvious that with the new chairman of ASIC, she's probably going to be on this even more. What you say as trustee to your beneficiaries, to your members, is really crucial. You've got to you can't have it give the wrong impression. It's not just about, well, you have $1 million when actually you've only got $10. It's actually also about making claims or representations. AI doesn't care if it's true. It doesn't care if the date it says for me to apply to be a professor is the 7th of July when actually it's the 30th of June. It doesn't care. That's just what it thought it was. I did actually generate this picture. I'm very proud of it. I'm going to patent the briefcase that is halfway up her leg that must be held there. Velcro. That seems like a very good idea. So the bottom line is, then I'll stop. Seems to me AI is most risky when substantive accuracy is required, and there are times for trustees and for others where that's clearly the case. We need to think carefully about the human in the loop. What role is that playing? How can we explain that? How can we manage that? I do want to encourage trustees to think carefully about what it actually takes to build a bespoke model that will work for them. I think it's far more maintenance and training and so on than they actually realize. I didn't talk about the need for specialist AI expertise as part of the duty of care, whether you're a trustee or a director. you're probably not going to be expert across everything that you do, and maybe AI is one area where you personally aren't. So you're going to need to source specialist knowledge. One of the things that concerns me at the moment is actually identifying where independent specialist knowledge about AI resides. Way too many of the people who give AI advice at the moment are in some ways conflicted in giving that advice because they're part of the industry or part of a consulting firm that actually is partnered up with someone. So I think we need to be very careful about that. Talk about the potential of reversal of onus. I want to finish with what for me is actually the most important point, but may not be for everybody. I believe that in some circumstances, trusteeship is an example, but robo-debt suggests that public administration and others, there might be other examples out there as well. The criteria that determine what is a good decision or a good outcome shift. So we still care about cost, really. We still care about accuracy. But we also want to know about transparency. We want to know who made the decision, who contributed to the decision, how we got there. We want to know about fairness. And fairness is all of that discussion around what constitutes fairness and how different people view it. And we want humanity and legitimacy. So one of my colleagues has written about whether, this is primarily in the context of the EU, whether you have a right to a human judge at court. Is there something innate, a human right, that you should have your case heard by a human, perhaps with the assistance of technology, but not have a machine make that decision? So ladies and gentlemen, after a little bit of a rocky start, thank you. Those are my thoughts. There's a much more detailed paper that's got lots of case names and all sorts of things in there to kind of make it look more exciting, or less exciting, depending on your perspective. Thank you very much.
Thank you again for coming along and sharing your insights and experience, specifically in relation to the issues that arise in the context of trusteeship and superannuation funds in particular. But some great thoughts to take away, I think, from today's discussion, one of which, in my mind at least, is just how difficult it is to know how AI might be used appropriately and how the outcome based on the use of AI might put us in a better or worse place than if we hadn't used AI in the first place. So thanks again for sharing with us your thoughts in this regard. Let's put our hands together and thanks, Doc. We look forward to seeing you at the next event. Thank you.